Polyukhovich is a constitutional case about the validity of an amendment to a Commonwealth Act called the War Crimes Act from 1945 in 1988. The War Crimes Amendment Act 1988 substantively altered the War Crimes Act. It intended to retrospectively punish the criminal conduct of those who committed serious war crimes in Europe during World War II and since then had become Australian residents or citizens. I have a video explaining how to acquire an Australian nationality, but that is not the point, sorry. The point is that the amendment said that if a person committed a war crime in Europe during a particular period of time past, the person would today be punished under the Act. This is called a retrospective law, a law that punishes past conduct. And more, the conduct the Act is now punishing did not even happen in Australia. It happened elsewhere in Europe. Can the Commonwealth Parliament enact this law? Hello everyone, my name is Renato Costa, this is Aussie Law, and today we'll look at a case called Polyukhovich and the Commonwealth from 1991. Is Section 9 of the War Crimes Act 1945 as amended invalid? That is the question that the High Court of Australia had to answer. Was the amendment validly enacted? Did it find support in an appropriate head of power? And if so, which one? The Commonwealth supported the legislation, saying it was grounded on both the defence power and the external affairs power. So what is it? In this case, we will see a certain disagreement between the justices of the High Court on whether the law can be characterized as a law with respect to the external affairs power of Section 5129, or to what extent the extraterritorial dimension of this power should be accepted. So I won't be focusing on the defense power, particularly in this video, but maybe I'll come back to this case at another time and discuss that aspect as well. And there were some other arguments as well that related to the punishment of past conduct and the usurpation of maybe judicial power of the Commonwealth, but I won't be touching on those topics either. What I want to show you is the opinion of the justices concerning the extraterritorial aspect of the external affairs power. What does it mean? What is the scope of Section 5129? Well, let's start with the majority. In this case, a majority of 6-1, with Justice Brennan in dissent, held that the War Crimes Act was a valid exercise of the external affairs power. Now, let's see why. Chief Justice Mason was of the opinion that the scope of the external affairs power was not confined to the implementation of treaties or the relationship with other countries. By taking a literal approach to the interpretation of the Constitution, His Honour said, "The grant of legislative power with respect to external affairs should be construed with all the generality that the words admit, in that, so construed, the power extends to matters and things as well as relationships outside Australia." Particularly in this case, Mason said, to the extent that Section 9 operates upon conduct which took place outside Australia and makes that conduct a criminal offence, the section is properly characterized as a law with respect to external affairs and is a valid exercise of power. So, even though it is not for the court to decide whether there is an interest or concern of Australia in this particular matter, because this would usurp a parliamentary function, it seems undoubtful that Australia has such an interest or concern in the subject matter of the legislation here, stemming from Australia's participation in the Second World War. All in all, for Chief Justice Mason, the externality of the conduct, which the law prescribes as the foundation of the criminal offence, is enough without more to constitute it as a law with respect to external affairs. In this respect, it makes no difference whether the law creates a criminal liability by reference to past or future conduct, so long as the conduct is external to Australia. Well, maybe you can see that this is an extremely wide view of this head of power. It doesn't matter if there is any connection to Australia at all. If the federal law regulates things, people or matters that are external to or outside the Australian territory, that law is valid under the External Affairs Power of Section 5129, according to Chief Justice Mason. Justice Dean also adopted a broad view of the External Affairs Power. For him, the first thing to be stressed out about Section 5129 of the Constitution for the purposes of the present case is that its reference to external affairs is unqualified. The paragraph does not refer to Australia's external affairs, nor does it limit the subject matter of the grant of power to external affairs which have some special connection with Australia. The word external means outside. As a matter of language, it carries no implication beyond that of location. The word affairs has a wide and indefinite meaning. It is appropriate to refer to relations, matters, or things. Justice Dawson also followed the same path, affirming that externality alone is sufficient, and that the external affairs power is capable by itself of providing the authority for the Commonwealth legislation extending to circumstances which are geographically external to Australia. Justice Gordon and Justice McHugh agreed. Justice Toohey also agreed with the outcome, but he said that the expression external affairs itself demands some sort of nexus or relation with Australia. However tenuous it may be, an external affair is a matter which is external in the sense that it lies outside Australia, but it is a matter which is of concern to Australia. This does not mean that it must be a matter touching Australia's relationship with other countries, though that would ordinarily be the case. But it does mean that it is a matter in which Australia has an interest. Whether a matter so qualifies is, in this respect, for the Parliament to determine. But the power assumes the existence of a national interest in some person, thing or matter that enables one to say that the subject of legislation concerns Australia. So all in all, His Honour found that the Act would be supported by the External Affairs Power, but there should be some sort of connection with Australia there. However, as I said, Justice Brennan disagreed. For him, the Act was not regulating the conduct of Australian citizens or residents, and ultimately, in his analysis, the Act had no support in Section 5129. Justice Brennan opposed the wide view promoted by Chief Justice Mason and the others in the majority. He was the only dissenting judge in this case. For him, Section 5129 does not arm the Commonwealth with power to enact laws governing affairs outside Australia with which Australia has no connection. It is of course for the Parliament to determine in the first instance whether there is any connection between Australia and a relationship, set of circumstances or field of activity which exists or occurs outside Australia and which a proposed law would purportedly affect. But if the legislative judgment cannot reasonably be supported, the law will be held to be outside the power conferred by Section 5129. It leaves no great lacuna in the plenitude of Australian legislative power to deny the character of law with respect to external affairs to a law which does no more than affect something or somebody unconnected with Australia, occurring or existing outside Australia. And so His Honour provided us with an example. Would a law be properly characterized as a law with respect to external affairs if it imposed a criminal penalty on a person who, being a citizen and resident of France, had dropped litter in a Parisian street 40 years ago? The limits of the power conferred by Section 5129 are, in a real sense, a guarantee of the immunity from harassment by Australian law of persons who, having no connection with Australia, engage in conduct elsewhere which does not affect Australian interests or concerns. It is pretty evident then that in His Honour's opinion, the law must have a connection with Australia. It must relate to Australian citizens or residents, or somehow relate to the protection of Australia and its laws. only in these circumstances could the federal law be validly enacted under the external affairs power. Mere externality would not be sufficient to characterize a law to that effect. The dominant view of the High Court of Australia in subsequent cases maintained that broad approach of Section 5129 adopted by the majority. As it seems, the High Court favours a wide view of the external affairs power, admitting that mere externality to Australia is sufficient to characterize a federal law. I hope you enjoyed this video. If you did, leave the like button below. And if you subscribe to our channel, you will see many other videos with cases, explanations, and everything about the Commonwealth of Australia Constitution and the Australian legal system. I hope to see you around.